Okay, so Thurman, I want to know what your thought was when I had the privilege of calling you on January 18th to tell you that the appeal was granted, you won the case, and that your son was going to be returned to you. Talk to me about that.
Well, you actually weren't the first to call me. Um, Law firm gave me a call at, I think it was around 9 in the morning, and I was at work. So I ended up walking outside and they gave me the news and probably did like 20 jumping jacks, did a little scream. You know? And then when I was done, then you called me and then I did it all over again because it kind of just reaffirmed it. But no, I was just excited. I was extremely excited.
The reason why I wanted to make sure to do a podcast is because this is an example of how the law and lawyers can affect the lives of real people. And I think, for what you went through, I mean, it was just so much. And kind of the question that the the lawyers all talked about was why? I mean, biologically, the child is not yours, but you had a connection to the child. So can you take us through that thought
Sure.
process of spending all the money, resources, energy, stress?
Yeah, yeah. I mean, it to me, it wasn't a very hard decision. I mean, I can't birth a child. I don't know anything about that, but um, to me, Thurman has always been my child. So I've had that father-son bond. That's the closest I know to a father-son bond with him since he was born, and that's not something I was really willing to give up. And on top of that, with the loss of his mother, um, that was really all I had left of her was him. I look at him and I could see her just about every day. So that's not something I wanted to give up as well. But I would just say it's just a connection. It's a bond. It's a father-son bond. Regardless of if we're blood or not, I have that bond with them. It's really I could explain.
And by the way, my name is Mike Nichols. I'm at the Nichols Law Firm. This is Jackie Moss, who was the trial attorney for this case, and then Lisa Schmidt, who was the outstanding and awesome hero and savior of this whole thing, the appellate counsel. We're going to walk through Taylor versus Brown. Jackie, you were the trial counsel, and you and I talked after we sort of had our pre-production meeting. And what I remembered and what jumped out at me was just how morose and affected and almost inconsolable you were after the trial that day. Can you just sort of share with us a little snapshot of your emotions?
Yeah, absolutely. So the majority of cases that I've done in the realm of family law, well, all of the cases that I've done, the highest thing that's been at stake is parenting time. A parent may gain or may lose some parenting time. And here the stakes were much higher, actually as high as they could be in the realm of family law.
Yeah.
Thurman's parental rights were at stake. And when the judge announced her decision, it really was a gut punch to me because I could tell from my very first interaction with Thurman and all the way through every step along the way that how much being a father meant to him, how much this bond meant to him with his child, and for the judge to essentially rip that away, I knew the pain that it would cause him and his family, and I felt that vicarious trauma. It was heartbreaking.
And then, I mean, within minutes of when you came back to the office building, I said, well, let's call my friend Lisa Speaker, who I've known for, 16, 17, 18 years. And in comes Lisa Schmidt, who's an attorney with the Speaker Law Firm. Lisa, what were your first thoughts when you got involved with this case?
So as an appellate lawyer, I read everything that happened in the case. I read the transcripts, I read all of the pleadings, and I'll tell you what, when I finished reading that transcript, I was like, how could the judge ignore what the child had been living for 3 to 4 years at that point? Basically, other than saying, oh yeah, established.
With this guy right here, right?
Right, exactly. The court said, yes, established custodial environment is with Thurman, but then spent the rest of the time talking about this stranger to the child without any consideration for the bond that had been established. And so for me, it seemed like it turned the whole thing on its head from the very beginning.
What I'm going to try to do is walk us through how we got to the point that we got to, which is Thurman really just fighting for the right to raise not his biological DNA child, but the young person who he thought was always his child. And it starts with an affidavit of parentage. And in the law, Jackie and Lisa, correct me, it's where a person who maybe he knows he's the father, maybe he thinks he's the father, but he signs an affidavit that is recognized in Michigan's statutory scheme. That's the person who is legally the father of the child, right? I mean, maybe you know you're the father, maybe you don't.
Yeah, so
Go ahead, Jackie. Are you there?
I hear the thought path that you're on, Mike, and you're kind of breaking up on my end anyway.
I want you to go ahead and explain what the affidavit of parentage is.
Okay, you had froze, you were kind of freezing and unfreezing, you're back to normal now. You were asking about the affidavit of parentage,
What is an affidavit of parentage?
Yes, so when a child is born out of wedlock, we obviously we always know who the mother of the child is. If the parties are married, then it's presumed that the husband is the father of the child. When there is no marriage and the child is born, and that's where an affidavit of parentage comes into play. And it's simply it's a sworn statement by both parties that the male figure is in fact the legal father of the child, by both parties signing that, and it's notarized, that bestows upon that male figure all of the legal rights associated with parenthood. And that's how Thurman became the legal father of his son.
And then what happened in this case was Thurman signs the affidavit of parentage, but unfortunately, the mother is having, we call it meretricious or an illicit affair with another person. And that person is actually, as it turns out, the DNA biological father of the child in question. And then, oddly enough, the mother dies. Was it almost a year before the child's first birthday, or I'm right before the child's first birthday?
Died a month and 3 days after his first birthday.
Unbelievable. Unbelievable. And then we have coming into the picture shortly after that, the gentleman who started to realize maybe this is my biological child, but that wasn't the first time he had notice. He had notice prior to the child's birth, and we'll find out more about what his reaction was when we get to a later point in the podcast. But he decides he's going to launch litigation right before the statute of limitations expires for him to do that. So maybe, Lisa, you could explain what the statute of limitations is when there's an affidavit of parentage and somebody wants to come in and revoke that affidavit of parentage and say, I'm the dad, that's my child.
Sure. So we're talking about a law called the Revocation of Paternity Act. I think it was passed in 2012. And that law says that in the interest of protecting children's connections with their family and also in providing them finality so that they can move forward with their known family, any attempt to revoke paternity, except in certain circumstances that don't apply here, has to be filed within 3 years of the child's birth or 1 year after the affidavit of parentage is signed, whichever is earlier. Sorry, I had to clarify that in my mind. And so it is the purpose is that we want to make sure that this question is answered before the child has a lengthy period of time with someone who turns out is not the father.
Absolutely. I mean, that just makes sense.
Yep.
So what happened in this situation? How close to that statute of limitations was the, I guess it's a complaint? And why is it a complaint, Lisa?
So it's a complaint because anytime you have two people versus one another in family law, it is considered a complaint. Complaint for divorce, complaint for separate maintenance, complaint for revocation of paternity. So that's the term that is used when two people are going up against each other in court. This case was filed, I believe, 40 days before the statute ran. It's 3 years that he had to do it, and he was within just over a month before he would have been forever barred from the issue.
And this is where I'm just awash in amazement with our client Thurman, with your position to fight for the ability to raise this young man who you accepted as your child. And maybe you can talk about why you made that decision, Thurman.
Once again, like I said, it wasn't a hard decision. To me, he's my son. He's named after me, you know. It wasn't a hard decision. It more or less was, am I doing the right thing kind of on my part by, you know, I know this guy's saying he's the bio father. Should I let him see him or shouldn't I? That was more the dilemma for me. But just knowing what I know of him, it was hard to not fight for him because I just felt like he'd be in a better place with me. I know he would.
And there was some discussion during the trial courts when the trial court judge issued the opinion about that whole, when bio dad starts communicating with you, your response, and the trial court judge sort of, we thought erroneously, focused on you trying to protect your child and fight for your right to maintain that finality. You know, he's mine, I'm raising him, I signed the affidavit of parentage. And maybe, you know, Jackie, could you reflect on that and why you made some of the strategic choices that you made to argue the things that you did?
Sure. So in any lawsuit, anyone that's been to court knows it's a roll of the dice when you're leaving the decision up to someone else, whether that's the jury or the judge. And that was no different here. Ever since my first conversation with Thurman, and as I became acclimated with the facts of the case, it was clear to me that he did have a very strong case. But that being said, if we could remove the decision from the judge's hands if possible, I wanted to do that. And it started out with our answer to the complaint. We asserted the affirmative defensive laches, which essentially laches is saying opposing or plaintiff, you took too long to initiate your suit. The judge was not receptive to that argument. Shortly thereafter, I filed a motion to dismiss based on some of what I thought were faults in the initial pleadings, specifically with the affidavit that was attached to the complaint. The trial court judge, again, also ruled against us there, and the case ensued, and ultimately she made her decision, and luckily Lisa made a spectacular argument. The Court of Appeals was receptive to that. They reviewed the case history very thoroughly and realized that an error was made and was able to correct that error.
And we talked a lot. I want to get to Lisa's strategy in just a second, but we see your office door. It's right across the hall from my office. You and I talked a lot about strategy and what to argue and what not to argue. And there were a lot of things that you could not get into that I thought maybe we should, because there were some things that were, I guess maybe we'll say, negative factors about the biological dad, the dad whose DNA was connected to this child, but we felt the judge needs to hear about why it's better to be with our client, with Thurman, than to be with biological dad, and we could not get into that. But then, you know, we lose because the judge focused. I mean, really, I read that transcript, 90% maybe on, okay, it's the biological dad's child. He has a constitutional right to raise this child. And that was a big part of that decision. And then, you know, I probably the best thing I did on this whole case was to decide, let's call the Speaker law firm. And then we got Lisa Schmidt coming in on the case. And so Lisa, you know, knowing what you knew about the case and what a great client we had, how the equitable factors, we call them as lawyers, the good guy stuff, were so heavily in our favor. How did you decide to argue what you argued? Because your argument was brilliant in the Court of Appeals.
Sure. So whenever we're at the Court of Appeals level, we try to look for what we call legal errors instead of factual errors, because the trial courts are always given the benefit of the doubt when it comes to weighing the facts, because they're the ones sitting in the courtroom looking at the parties who are testifying and the witnesses. So they have the best sense of what is true and maybe what doesn't come through clearly on the record.
Right.
So whenever we can, we focus on the legal issues. Now, in this case, the legal issues were very, very apparent. You already hinted at the first one, which was the constitutional issue. And to me, this was the most important one. We'll get to it later. The Court of Appeals put its focus elsewhere, but to me, the biggest issue was that the court called it an overwhelming factor that the biological father was the biological father, basically putting DNA above all. And there's a U.S. Supreme Court case, it's Lehr, L-E-H-R, that says that that's not enough. It's not enough to have a genetic tie, that a biological father has to do something in order to trigger those constitutional protections. In Michigan law, the Affidavit of Parentage Act, the Acknowledgement of Parentage Act, where we get those affidavits of paternity, says that doing something in an unmarried case is signing that affidavit. And it wasn't the biological father who had done that thing, that was our. And so I felt very strongly that the trial court put the rights on the wrong dad, and that we should be addressing that. In addition, we talked about, like you said, the good guy factors, the fact that the court had basically ignored the hard work that our client had done in raising the child so far, and the less than favorable factors with regard to the biological father. And then finally, the technical issues with the pleadings that Jackie had spoken of and that we're going to get into a little later.
Right. And, you know, at this point in the case, what we've had is, you know, a guy who was in a relationship but not married to the biological mother, right, Thurman? You guys were not married.
Engaged.
You took care of her without getting into the details. There were some struggles there, and you decided to raise this child as your child. Seems like a great kid. You decide to invest the resources, the energy, the money, the stress into an appeal after, because the trial was 3 days, right?
Yes.
Not consecutive, but over the course of time. And intense. You had family members there supporting you. And I know I wasn't there on the third day, unfortunately, but I know from talking with Jackie, all of the emotion, the crying, the tears, everybody retching and wrought with and just anxiety. And yet you decide you're going to go on and fight for this young man. I want to know why. What motivated you in that moment? You must have been in one of your darkest hours.
Um, Honestly, the only way I could really describe it is like a zone. Um, when his biological mother passed, the same sort of thing happened. It was almost like a light switch clicked and you just focus on what needs to be done instead of the sad stuff and, what's going on around you. So similar to when she passed, once I found out I lost the trial, I kind of just tried to block everything out and said, hey, what's the next step? Since I heard from Jackie, there's a next step I can take. And you also have to think, I don't think I'd be able to live with myself if I didn't do everything I could.
At least
To
make the effort.
Exactly. If I had just given up, I don't think I'd be able to live with myself because of how strong our bond is. I would have just been giving that up. So I had to just keep going. It's just I just kind of zoned out and went for it.
Tell us about why that bond is so strong. Can you just give us a little window into your world with your son?
Sure. Once again, without going into details, his mother was sick, and we fought through a lot of struggles together, and that by itself it bonded the two of us. When she had my son, it was probably the happiest I've seen her ever, anybody ever. And that in return made me happy because everything I had put into our relationship was kind of validated by that. So when he was born, it was a blessing to both of us. It was just we were extremely happy. And then when she passed, I knew I was all he had. So I kind of doubled up my efforts when it came to being a father, and I tried to do everything I could to be father and mother for a time, and do what I could to just keep him happy. That's what was really on my mind, was just making sure he was happy and didn't miss too much of what he was missing. You know what I mean?
So we had a lot of pressure, especially Lisa, at the Court of Appeals to try to make the dream that you had to finish the job that you're trying to finish raising that young man. So Lisa, as I read the opinion, there were two big things I thought that were the issues that the Court of Appeals turned its opinion on. Can you elaborate on those for us?
Sure. So the Court of Appeals wanted to focus on the idea that it takes an affidavit to set aside an affidavit. We've
Right.
talked a lot about the affidavit of parentage being a sworn statement that says that this is going to be the father of the child. To set one of those aside, you need an affidavit that lays out one of a handful, or at least one of a handful of reasons why it should be set aside. The two that are important here are mistake of fact, and I'm going to quote this one, newly discovered evidence that by due diligence could not have been found before the acknowledgement was signed. So in this case, that first complaint was not paired with an affidavit that established those facts. There was an affidavit filed right away, but it just laid out like where the child lived and so forth.
Right.
It's a standard form that gets filed in every case. It wasn't until after Jackie filed his motion to dismiss that they responded with the affidavit that laid out the facts. Now, remember, we talked about that 3-year limit. That affidavit establishing the facts was not filed until after that 3 years. So the first issue that the court focused on was that that affidavit was untimely and therefore too late. You missed your deadline.
Right.
So that was the first issue. And then the second was the content of the affidavit. So remember, we talked about mistake of fact and newly discovered evidence with the due diligence requirement. So the biological father's affidavit said that, or I should say, did not say that the biological father was under any mistake of fact. He had known about the child's pregnancy, or about the mother's pregnancy with the child, from like 2 months after the child was conceived.
Right.
Instead, what the affidavit said was that our client was mistakenly believing that he was the father. There was no mistake by the person filing the complaint. The mistake was by the person whose rights were going to be taken away. And the court said that's not enough, that there needed to be a mistake by the person who was trying to assert their right.
Right. Right. And at footnote, I think it's footnote 20, the Court of Appeals picked up on the testimony at the trial that when the plaintiff, the biological dad, found out that she may be pregnant, his reaction was, here's $400 to go get an abortion.
And then under the other prong, that newly discovered evidence that by due diligence could not have been found, the trial court only addressed that first part, the new evidence. It said, well, we didn't have DNA evidence before the child was born, so there was nothing, the newly discovered evidence happened while this trial was happening, except that there was nothing stopping the biological father from being present at the time the child was born, other than him trying to conceal the relationship. If he had been present at the birth of the child, then they could have done a DNA test right then and there, if not during the pregnancy.
Right.
And then there would have been no question about who should have been signing that affidavit. The Court of Appeals said that the trial court made a mistake because it did not determine whether the biological father had exercised due diligence, when in fact the facts were very clear that he could have and didn't.
Right.
Absolutely. Lisa, one thing I wanted you to, could you talk about the requirements for the affidavit? So the affidavit was faulty also in that the bio dad, he alleged facts that he did not have direct knowledge to himself. That was a part of the issue, was it not?
That's correct. He did say that he would allege things that our client knew or didn't know. He does not know what is in our client's head. In fact, they had only ever met on one occasion, I believe, and that was, again, trying to cover up for the fact that there was a relationship going on. So there was no way for him to have known what was known or not known at the time the affidavit was signed.
So, Lisa, we trial lawyers call you appellate lawyers the second team. You try to clean up the messes. And, I've met many appellate lawyers. I know that, your typical attorney demeanor is bookish, and you try to keep the emotion out of it. And you're just working with what judges and lawyers call the dead record. It's not hearing and feeling the human emotion, but what's on paper. What got you so fired up about this case?
So now you're going to get into my history. I was a trial lawyer for a decade before I started doing appellate work. I actually was involved in the very first revocation of paternity case filed in Wayne County. And so I've been on the ground floor for revocation cases since the beginning, and I feel very strongly about the parental rights that are involved in them. So part of it was you hit one of my passions. But also it's just such a compelling story. I mean, we have this child who's already lost his mother and now is losing the person that he knows to be his father and getting placed with a stranger who, as we've discussed, has some questionable stuff going on in his life already. And the risk to that child of the trauma of the transition and also what could potentially happen after in that household really hit my heart.
Yeah, I mean, our guy Thurman is, man, I just can't say enough about what a hero he is. And I know that I think I got the email from your office, Lisa. So you probably saw the order from the Court of Appeals Thursday, January 18th, 1 week ago tonight that we're taping this on the 25th. What was your first reaction?
So this is kind of a funny part because I work remotely for the firm and I'm located in California. So the decision came out before I was awake. I woke up to a text message from my boss saying we won, and I hurried to read the opinion. I'll tell you what, I have never rushed to get to work so fast.
And I got to call Jackie as Jackie was walking into court in, I think, Jackson County. And I just remembered how Jackie was so down in the dumps the day that the trial court issued the opinion. The only superlative I have is inconsolable. So when I called you, Jackie, what was your reaction?
So you're correct. I was in Jackson County and I was meeting with a client. I was technically supposed to be in front of the judge at this particular time. Due to the weather that day, the client was a little bit late, so we were still outside of the courtroom. I knew that you knew I should be in court. So when I saw your number on, come across my caller ID,
Right. It was like 2 minutes before court was supposed to start. It was 9:58 or something. Yeah.
I told the client that I was with, I said, excuse me, this has to be important. This is my boss. And when I answered the call and you shared the news with me, I was on cloud nine for the rest of the day. I couldn't wait to get back to the office so that I could establish a line of communication with Thurman and talk about the next steps moving forward. I do want to take a second to acknowledge, I know that Thurman, isn't doing any of this for kudos or anything like that, but I will say from my very first interaction with him, he's been all in from day one, in the sense that when he first found out of the pregnancy, he immediately, like, something switched and he went into dad mode. He changed his he purchased a home. They were renting prior to that. So he purchased a home. He purchased a safer vehicle. He was doing all of these steps in preparation of being a father. So from day one, before the child even arrived, Thurman was in that role and never faltered once we received a adverse ruling at the trial court level.
Yeah. Stalwart, straight and stalwart. That's all I can say about Thurman. What an incredible man. And so it's been a week, and Thurman, Jackie and I, lawyers don't get to, let our hair down a lot, but Jackie and I went to a place called Buddy's Pub just down the street from our firm, had a celebratory beer, and you sent us video of your child being delivered to you. It was awesome. What's the week been like? It's been a week.
It's been good, man. It's been really good. There's a huge just weight off of me. That zone I was in, I was able to come out of it. I'm able to be myself. And I'm just able to enjoy my family. I got my wife here, my son's here. I have had a lot of family coming by to see him, make sure he's all right, and double check everything. But for the most part, I'm just still taking it in. I'm happy my little guy's here and we're able to be a family again. So everything's been great.
What's your takeaway about the legal system from all this?
Honestly, it's been good. I think you mentioned something to me before about how people do view lawyers as, kind of money hungry and, they just want the job and that. But, ever since I talked to about 3 lawyers before I talked to Jackie, and his demeanor.
Oh, wait, we were the 4th law firm you talked to?
Oh yeah. About
I gotta talk to the marketing department. Anyway, go ahead.
Well, I was looking around, I didn't want to just call somebody randomly. I don't know anything about lawyers, but I called a few people, and just the way they were talking, they had that demeanor of sure, we'll take the job sort of thing. But when I talked to Jackie, he sounded more sincere, like he understood what I was going through right off the bat. And so that's what kind of led me to you guys. And my son's biological great grandmother actually When I told her I'm thinking about this Nichols law firm, she said, "Oh yeah, I've been around for a while, and they're one of the better ones." So I actually researched you, Mr. Nichols, and seen that you were like writing laws and things like that, and I was like, that's a win for me. You know, I got Jackie who's comforting me. This guy knows what he's doing, so it kind of was a no-brainer at that point who I was going to choose.
Well, I have to put this plug in for my friend, Lisa Schmidt. You are awesome and amazing. But the first thought I had when we had that adverse decision was, I've known Lisa Speaker for 17, 18 years, and what a hard charging, hard working lawyer she is, who wants to do the right thing and win. And so part of it is surround yourself with good people, associate with good people, make a decision to raise your standards, and that's just how you get to the results that we just were fortunate. The moon, sun, and the stars aligned. We got the result that we got. So I'm glad to hear you say that, Thurman, and thank you. And Lisa, what are your takeaways after all this?
Well, so I was ecstatic to have won this one. I was very excited. One thing we didn't talk about is when you're doing the oral argument, sometimes you have a very quiet panel of judges. You're sitting there talking to three judges, or
That was
usually
not this
standing.
case.
And in this case, one of the judges literally interrupted my introduction to prove my point. And just the high from that argument, I felt very strongly that in favor that we were going to win right away. My boss said the same thing. Lisa Speaker and I were constant. I got done with my oral argument and she was texting me because she was in the courtroom for another case and she was like, "I think we're going to win." So
Yeah.
it was very good. As far as a takeaway, I am I am very happy that this decision was as strongly in favor of our client as it was. Um, I continue to say this area of the law needs more good decisions.
Oh,
So
absolutely. Yeah.
we've got a good one, and hopefully we can build on that in the future. Um, Man, it was a good decision, and read the footnotes.
Yeah, the statute needs to be cleaned up because when I read the language that talks about things like the presumed father, and I transposed who the presumed father is in my mind and what apparently the statute actually is supposed to say, like they got to clean this up.
Yeah.
Clean it
This is
up.
the circumstance of, legislation and negotiations over time. And so the language in the section that talks about the factors doesn't match the language that talks about the setting aside of an affidavit. And so, yeah, we definitely need some more guidance. And here we have a case that is making it clear that those requirements in the affidavit, they mean something.
Right.
And you need to do more than just say a mistake was made. You have to actually have a mistaken belief, and there has to have actually been something preventing you from asserting it at the time the child was born. And
Yeah.
so I think it's a great decision.
Jackie, your takeaway.
My takeaway is the importance of making a good record. I feel like Thurman and the two witnesses that we also called to testify on his behalf, everyone did a good job. I think we gave Lisa the necessary ammunition that she needed to put forth a good argument. So that was the big takeaway for me. As I've read the opinion a few times now, and I went back and reread the pleadings, and yeah, just really the takeaway for me is the importance of establishing a good record. So if an appeal is necessary, the record can support what needs to be done.
Yeah,
And
and
this is an
even
area where I need to shout out Jackie, because a lot of times when we get records from trial counsel, we as appellate lawyers are like, "Oh, I wish that they would have raised this issue, or I wish that they would have said this." And Jackie hit every note. We had a really good record going in, so we were able to build off of that for the appeal.
yeah, we talked a lot about, different decisions, and in the heat of the moment, it's hard to make the decision about what's right, what should I argue, what should I leave alone. But man, Jackie's passion, I can't say enough about, and it really hit home to me. when he came back after the trial court issued its opinion and order. And I mean, I could not, there was nothing I could say to make Jackie feel any better. And it took probably a week for him to actually start to turn that frown upside down, as they say. And
I don't
I
have
wanted,
a hard time saying this in public, but this was the only I actually when I got back to the car, I shed a couple of tears. That had never happened before. That I tried not to get overly emotionally involved in cases, but the facts of his case and the story was so compelling, and Thurman is such a likable client that I wanted to do my best for him, and the tears came from a feeling of I felt like I did everything within my power to ensure that what didn't happen happened, and we got the ruling, and I literally felt defeated for the first time in my career.
yeah, and I just want to say three things in closing. First, Thurman, my water bottle, make sure you raise your son to be a Lions fan.
I,
Number
I was I'm a Cardinals fan.
Oh my God.
Uh-oh.
All right. Remember that discount we talked about? It's off. I'm kidding. But number two, I wanted to talk about this not only because it's so interesting and such an odd and unique and fascinating story, but because this is how the law can connect people to what legislators write in the code books and what judges issue down as opinions to interpret both the common law, which is supposedly the law that existed in merry old England before we had statutes, but the statutes. And number three, man, our client is a hero. Thurman.
I appreciate really do. But and I'll honestly, I'm just being a dad, just doing what I know to be a dad. That's all
Thanks.
it is.
You're awesome.
Hey,
Raise that kid.
I appreciate you. I know my son appreciates you. My wife appreciates you. And one thing I will say is the little things do matter. You guys did a lot of little things that helped me get through it, stay in my zone, where, somebody else could have said the wrong thing and it could have completely thrown me off. So
Sure.
appreciate all the little things you guys did. Taking the call. I know I was probably rambling and just throwing a million things at you.
A little bit.
I did that to you. And you're like, man, he has no idea what he's talking about. But I do appreciate you guys sticking with me and making me get this result that I got. It means the world.
Everybody, thank you for your good work. Thurman, keep it up.
Got it.
Look forward to seeing pictures of you and your son down the road.
Hey. Oh, also, I gave a shout out to Lisa. I'm not sure if you've seen that, but tons of people reacted to that. And I'd love to do it for Jackie. I don't have you guys' sites on social media, so I'll look that up. But I know a lot of people were wanting to thank you guys. So from them to you, from me, thank you from them. And I'll look forward to seeing you guys on social media and all that other good stuff.
Right.
Thank you for that, Thurman, and you're very welcome.
Everybody, thanks for your great work.
Thank you for extending the platform to talk about this important issue, Mike.